Okay, hello everyone. We are back and we are doing a review on chapter 11 concerning real estate contracts. Chances are we may have to break this up into two quick reviews because it's very important that you understand these contracts in here. And I know that you're getting the bulk meaning of it in your classes, which you should be doing. But this chapter is one of our kind of lengthy chapters. Florida Real Estate Principle and Practice by Miss Linda. She does an excellent job in the chapter, so make sure that you are clear on your contracts. If you go over starting with page 230, the authority of real estate licensees to prepare contracts. Now it tells you starting with line 22, real estate licensees are allowed to assist buyers and sellers with the drawing up of 4 types of contracts. The first one they have here is a listing agreement. Basically is what it's stating. This listing agreement is between the broker and the seller, because now the broker is going to list the property for the seller in order to get it sold. We can also assist as a buyer brokerage agreement. That's between the broker and the buyer. Now you are helping that buyer to find property. We also can assist with the sales and purchase. Now you have found that buyer a property. Yay, you're ready to go. And then of course the option contract. Option contract extends the closing date for a longer period of time than what we actually have. The book actually tells you that it is an agreement to keep open a specified period of time and offer to sell or lease properties. So these are 4 that we do have authority to assist the buyers and sellers with. Look over on the next page. What are the essentials of a contract? In other words, in order to have a valid contract, guys, you have to have contractual capacity, competent parties, okay? You have to have mutual consent, offer and acceptance. Everybody has to agree. We now have this executed contract is what you're looking at. Legality of objects, you got to have something. There's got to be an object, a purpose, okay? And then consideration. Those 4 things, they make up a valid contract. Flip over to the next page. Now, in order for your contract to be enforceable, which means you can probably take someone to court about it, okay? That goes up under what we call the statute of fraud. But make sure, number 1, it has to be in writing and signed for it to be enforceable, which means you can take someone to court on it. And what are the ones that the statute of fraud will apply to? If you look at it, it tells you purchase and sales contract, option contract, deed and mortgage instrument, loan agreements for a term longer than 1 year, and a listing agreement for a term longer than 1 year, okay? Now, there's a certain time period, though, that you have that you can present your case concerning these particular contracts. That's known as a statute of limitation. So statute of fraud is saying if it's in writing, if it's signed and in writing, yes, it is enforceable. Statute of limitation says, and this is your time period for it to be enforceable. If it is in writing, 5 years. If it is an oral contract, 4 years. If you have half and half, 5 for the written, 4 for the oral is what they're talking about. Transfer of real property. Here again, remember I told you at the beginning of these reviews, when you start seeing things over and over, repeat, make sure you understand them, you're clear with it. Transfer of real property, it tells you real estate sales purchase contracts must be in writing and signed by all parties who are bound by the agreement. In writing and signed, in writing and signed. On 233, you have a voidable contract because of the manner or method to which it was brought about. One of the parties is permitted to avoid any contractual duties, or you have an unenforceable contract. You should know what that is right there. Appears to have all the essential elements, but it cannot be enforced in court. Why? And they give you an example there. Well, we kind of went over one before. Over on the next page, you have a couple of other contracts classified. You have bilateral and unilateral. Let the verbiage kind of help you out with that. Bilateral means you've got 2 parties that are obligated on that contract. unilateral, that means you have one party that's obligated on that. Down below you have express contract and implied contract. And express contract is pretty much you have the executed contract, everything went according, you went to closing, didn't really have any problems, end of that story. Implied contract, you thought that chandelier that you saw in the house when you went to see it went along with the sale, but it wasn't on the contract. Implied contract, you implied, you thought that something was going to go along with the sale, a personal item or something, and it was not on the contract, so that was implied. Over on page 235, you have an executory contract. Executory contract is an agreement between parties that involve promise to complete at a future date, okay? So that's what you're looking at on there. On 236, when you're doing your negotiation, make sure you know the difference between an offerer and an offeree. Okay, Ken is the offerer. The offerer is the person making the offer. The offeree is the person receiving the offer. Then they start talking about counter. What happens when you do a counter? Well, when you do a counter, it will either be accepted or it will not. If it is not accepted, then that offer is dead. If it is accepted, then you go on. Termination of contracts on page 237. Make sure you know ways an offer is terminated. They are called wild card. But to kind of help you out here, if you look at all of the ways that the offer is terminated, withdrawal by offerer, insanity, lapse of time, death, counter, acceptance, rejection, destruction of the property, something has happened to either the buyer or the seller or the property or the broker, okay? So these are ways that an offer can be terminated, but something has happened to one of those, property, the buyer, the seller, the broker, after you have had an executed contract, but you can terminate it. Make sure you read over that. On page 238, remedies for breach. Make sure you know specific performances. The court will order you to do it. You said you were going to do it on that contract. Well, now they have to make you do it on that contract. Liquidation damages, amount of damage, usually the earnest money deposit is going to clear the damage that you made. That's your liquidation damages. Recession, the contract is concealed and the parties are restored to their original possession. And then compensatory damages involves a lawsuit to recover the actual amount of the monetary loss to either party, okay? Make sure you know these four definitions, guys. Flip on over to page 239. Now they're talking about contracts important to real estate agents, and the reason why, basically, go to 240. One of the main reasons why also these three different contracts that we're going to talk real quick on here, that literally tells the real estate licensee who's going to get paid as far as the commission for the sale of that property. So starting off on page 240 in the gray box, you have three types. Open listing. If you see a listing, these listings are usually in the MLS. If you see that listing and down to the bottom it says an open listing, that means one or more brokers is the agent, but who only to the broker who sells commission. So basically what open listing is stating, look, I may have, from Coldwell Bankers, I may have actually list the property, but whoever brings me in a buyer who is ready, willing, and able, that's who gets paid all of the commission, okay? So open listing is open to all brokers, to all real estate agents, and the first agent or the agent that brings in a buyer who's ready, willing, and able, that's who gets all of the commission, not the agent that listed the property. If it's an open agent, the commission will go to the agent who brings the buyer in, who's ready, willing, and able. Okay, exclusive agent. That particular listing, the commission will go to the broker who is listing the property unless the owner finds the buyer himself. to the listing agent if not sold by the owner. So if the owner sells it or brings a buyer to purchase a property, no one gets any fee for it, okay? Even the listing agent doesn't get commission for it. Now, the exclusive right of sales, it doesn't matter who brings in the buyer, the listing agent is the one who will get commission for it, okay? So open listing, that's open to all agents, but the one who brings the buyer who is ready, willing, and able, that's who gets all of the commission. Exclusive agent, that goes to the listing agent unless the seller sells the property himself. An exclusive right of sales, that will go to the listing agent regardless of who brings in the buyer, okay? They also have a net listing. Open exclusive right of sales listing can also be a net listing. Is created when a seller agrees to sell a property for a stated amount. So a net listing is an example. Let's just say the seller says, look, I just want 200K out of it. I don't care what you sell it for. And then you sell it for 250,000, then the 50,000 is what the agent will get. The seller just wants his stated amount, okay? Go on over. Now the next couple of pages, they talk about them also specifically, so make sure you read over them. On page 241, multiple listing services, we kind of touched on that a little in chapter 2. Multiple listing services is where you will see the broker actually list their property, the properties for sale. When you hear talks of the listing agent, they're listing them in the multiple listing services. On page 242, they're continuing on talking about brokers' compensation. You already know in the state of Florida, brokers' commission is negotiable. There is no set percent for all brokers in the state of Florida. It's not there. On page 242, they're talking about the option contract in detail. 243, the unilateral contract in detail. Make sure you read over that, guys. Your sales and purchase contract. On page 245, they talking about the power of attorney. Line 4-5 is a written legal document designated someone else to sign for you. I think a lot of you already know what that is, okay? And go on over to 246, your lovely radon gas disclosure. In the state of Florida, we don't really have a lot of problems with radon gas. In the event, though, that you have a buyer that wants a radon gas testing, that's something that they have to pay for. Lead-based paint, line 9 through 18, that is something that we have in the state of Florida. If you have a house that was purchased before the year of 1978, you have to make sure that the lead-based paint disclosure is given to the buyer, letting them know, hey, there may still be some poison kind of in the paint there. 247, homeowners association disclosure. Make sure that that is given, and it tells you the homeowners association is a Florida corporation, a corporation responsible for the operation of a community or a more mobile home division. Okay, over on page 248, 249, they're talking more about property tax disclosures, building codes violation, timeshare resale listing agreement. Make sure you read over that information as well. And the last thing on page 251, misrepresentation and fraud. Guys, line 10 through 16 is basically telling you, number one, in order for your license, if in the event that you run into a situation where you're dealing with misrepresentation, in order for literally your license to be labeled as fraudulent, as you can see, line 10 through 16, it's giving you 4 different things that has to be found in order for your license to be labeled fraudulent. All 4 of those particular situations must be found in order for that to be the case. So make sure that you read over that, guys. If you have any questions, certainly get back with us and let us know, okay?